I'm Jonathan, and we're going to be talking about APS conditions and drafting issues. Good, fun stuff. This is like the kind of presentation where people at home now are like kind of like going to like turn over their lasagna or start the dishwasher. And when they're actually in this bind in the future, they would have wished they had listened and paid attention. Like one thing today that you pull out today can save you from lawsuits, save you from a lot of headaches, and your life is going to be so much better as a result. And don't have to worry about like notes. I see Jim's like all set to go with his pen and everything, but you're gonna get the PDF of this, don't worry. So if you can't sleep at night, you can flip through the PDF and it'll put you to sleep. My contact information is there, so you can reach out to me anytime. As I was mentioning before the presentation, I was a little late today. I had somebody call me in today. I get all sorts of scenarios all the time, people contacting me and they're like, I'm thinking about doing this, doing that, you know, what is your take on this? And I'm listening to this scenario and I won't go too much into it, but basically somebody calls me up and says, look, my neighbor wants to buy a piece of my land and I got a couple of acres and they want to buy an acre of my land. I'm like, where are you? Oh, I'm up north, Muskoka area. Okay, fine. How much are they paying? And they're like, we agreed 50,000 and then went down to 35,000. So we're all looking, right? Because like, what can you buy for $35,000, right? You can buy a parking spot, maybe up in like a condo in Aurora, maybe. That's about it, not even in Toronto. I said, look, I don't know you, I don't know the property. All I can tell you is this much. If it's my property and I'm gonna go sell it, it sounds a lot more attractive to me as a 2 acre than a 1 acre. I don't care how unusable the land is. $35,000 is bupkis, so please, you know, really reconsider this. And it's nice to meet people early on as a lawyer. And, you know, I've worked with one agent, another agent. They told me this, they told me that. Now I'm working with a great agent, but I'm still confused and I want to talk to a lawyer. And it's nice to have that comfort level. So one thing I will say is in general, and we're talking about things, a lot of disasters could be averted if I have that conversation before they sign the contract rather than after they sign the contract and it's firm. Not that you all don't know what you're doing in your fields, but remember something. Jim's heard this in every presentation, but if you don't tell the client, I really think you need to speak to the lawyer, I think you need to speak to the accountant, what's going to happen is you're deemed to give them that advice, and then it's on your neck. So you see a situation come up, client comes to you, I want to do this, I want to do that. Okay, that's interesting. You want to sell that piece. Okay, there's going to be a severance, there's going to be this. You know what? I think it's a really good stage now to speak to a lawyer that understands in real estate before we jump any further. Why is this good for you? It may mean that they may not have a transaction immediately, but they're not going to do a transaction they're going to regret and be mad at you about. Plus, they'll be so happy with you that you help them that they'll come to you for everything else. So things to think about. Our law firm, I mentioned before, real estate, corporate, commercial, wills and estates. So we do the whole gamut there. And we have multiple locations, but we are paperless and virtual. This is making life very, very easy. I still get people asking, I'm going on vacation, I have a scenario, do I have to be here for the closing? 99.99% of the time you do not. Most builders are accepting our documentation the way we're signing it. Banks, the same thing. So let's say Diana and I are having an appointment, which we may have had in the past. So Diana will be on her laptop, I'm on my laptop, I send her the link on the phone. And on our phones, we're actually hand signing, hand initialing everything. That's the difference between that and DocuSign. So the system we use is called Singraphy. So that's why we went for that system. And things for you all to think about, I've mentioned in the past, but as you're going forward, when you're meeting with your clients, not the worst idea to have a setup where you're verifying their ID as soon as possible. And there's electronic means to do that now. When you're meeting with them and you're meeting with them virtually, recording the appointment, let them know, I'll just let you know we're on Zoom right now, I'm recording the appointment. The more things you're advising, and especially when there's contentious issues and you have evidence that these discussions happened, these are going to make your lives a lot easier. I'm seeing more, and the reason I'm bringing it up is more and more lawsuits I'm seeing where clients are upset, they're suing their lawyers, suing their accountants, suing their real estate agent. And what happens for all of us if that happens is you have to go into your computer now, you have to go dig up old emails. It's a big pain in the butt to recreate, and if everything was done verbally, and show of hands, how many of you have those clients that are kind of sketchy or contentious and they love to do everything on the phone and never love to send anything in writing? I see some nods, right? As soon as you see that, what do we do about that? We finish the conversation. We come straight home to our computer. So-and-so, it was a pleasure meeting you at Starbucks this evening. As I mentioned at the appointment, it's very important to speak to your lawyer and accountant before you're proceeding with that transaction. Get as much things in writing, and if you can get them to acknowledge it, even better, okay? And the last thing I'm gonna mention, because I mention this all the time, but when you give that advice in writing, when you're about to enter into the transaction, do the one more follow-up. I told you in writing to go speak to your lawyer and accountant. Did you get all the information you needed? Are you comfortable going ahead with the transaction? Do that reaffirmation. If they come back to you and say, you know what, I tried to contact the lawyer, they weren't available, so I didn't get legal advice, let's just go ahead anyways. Try to insist, depending on the circumstances, they get the professional advice that you're not the one giving it. Again, I had a person long time ago as a realtor, I remember, and their client messages them, I'm gonna sell a vacant piece of land, and it's zoned residential, is there an HST implication? And the realtor texted back, it's residential, so clearly HST does not apply, nothing to worry about. Sell the property, CRA comes back looking for their money from an HST perspective, guess who was on the hook for it? The realtor. That one text message destroyed them. So what I always do when I think about it, and people get kind of aggravated with me, is if somebody messages me and asks for legal advice over text message, I tell them, you know what? Here's my email. Please email me. Let's schedule a call. Things of this nature I like to do on email because we all get a little sloppy on text message, right? We don't use the best English. We kind of just fluff it off. Just so we know in court, those text messages can be used the same against us as emails. So be very careful of what you're putting in writing and how you're doing it. Okay, you know to connect us on social media. My podcast, been taping that, bringing on people and talking about the chosen life and what that means. And I've had people in the world of real estate and talking about their journey. So it's really interesting to meet all sorts of realtors, mortgage brokers, people from our industry and hearing their stories and how they went about it and where they are and what they're interested in. And one thing you'll learn as if you ever watch my podcast is people who are very successful in real estate have a lot more to their lives other than real estate. You know, whether they like cars, bodybuilding, stamp collecting, bird watching, traveling, whatever it is. And it's funny because I was just talking to a new realtor the other day, and I said to them, you know, if you really think you're gonna be successful in this industry, what are you doing from a networking perspective? Like, what do you do and get yourself out and about? You know, I've met so many realtors over my 20 plus years in this industry. I've met people who did photography classes, people that did skydiving, people in my yoga class. And it's funny, they are all going out networking, meeting people, fun activities together, and inevitably they end up doing transactions for everybody in the group. So one thing I'll say for the people at home, people here, if you get very busy and you get caught up with family and your own things and what be it, think about it. How often every week are you going out and interacting with people in a non-real estate setting and just getting to know people in general? You'd be shocked, you know. I could tell you from, like, for example, in yoga, I may not have done anybody's deal in the yoga classes themselves, but they send me all their friends and family. And it wasn't me coming and telling them, oh, I'm a real estate lawyer, send me all the deals. It was, we got to know each other, build a relationship, and then said, what do you do for a living? What do you do for a living? Oh, this is, yeah, if you know anybody, please, you know, but never any pressure. It's funny how those relationships build. So heavily encouraging people to go out there and live that chosen life. And anybody who hasn't read it yet, if you would like to read an interesting book, my book, The Bible 3.0, is out. I just finished a US book tour with Ollie. We drove all the way to San Diego and back, and we crossed the US. And yeah, it was fun meeting people and being at Barnes & Noble and people finding out about the book, and nothing to do with real estate, more about lifestyle. And I'm seeing now a lot of clients reaching out to me. It's now October going into November. People with anxiety, people are anxious, you know, interest rates, is it time to buy, not buy, am I gonna keep my job? It's amazing how the mind gets racing now. Like, we're entering the age, like it's gonna be in about 2 weeks, we're gonna daylight savings time again, it gets colder, you know, you wake up in the morning, it's dark, and a lot of stuff creeps in. I talk about that in my book, and how to have the best mindset, take care of your body, take care of your soul. So anyways, that's me, and that's my book. And we are here today, and in that mindset and thinking, how are we gonna draft agreements of purchase and sale? how we're not going to get sued, and how we're going to have happy clients. We can make this interactive, so I know Jim's going to jump in here and there, but all of you, no, Jim, come on. And things that I've noticed, I'll talk about a little bit of stories in between as well, and anybody has any questions or has any comments, please, feel free to raise your hand. So first of all, the deposit. Okay, this comes up time and time again. We're all experienced enough to know that there's this giant myth that I sign a deal, and if I don't bring the deposit, then I'm off the hook because I never gave you the deposit. So the only way there's going to be a binding deal is if I bring you that deposit check. That is false. If all of us from our AREA/Humber, if anybody here went through Humber, remember the thing about on the agreement of purchase sale, you're on page 5, 6, whatever it is, and then you're signing off and there's this little seal next to your name. That seal was like meant from like the King's Age when people used to stamp with their ring, right? So we kept those seals. Why do we have that seal? That seal is the consideration for a buyer. So if a buyer signs a deal, says, I'm going to bring you the deposit check, and then calls the next day and say, you know what? I changed my mind, and I'm not going to bring that deposit check. So this is not a firm deal. So I didn't give you any consideration. So sue me. I don't care. When the judge awards the decision for the seller still is going to get the deposit the same way as if the buyer had actually brought the deposit. So by not bringing the check, the buyer didn't save themselves any grief. But be careful on this. The courts kind of go all over the map here. So when the buyer's calling you and says, I know I had to bring the check within 24 hours, I'm on my way to the bank, my car broke down, the bank is closed, their computers are not working, whatever it is, we do have to give a little bit of grace here. Like, if it was me, I wouldn't go and sell the property the next day to somebody else knowing we have a firm deal and knowing the deposit check is on the way. So we got to take each one on a case-by-case basis. And we've all experienced this or heard somebody who's experienced it, and it sucks when you're in that situation. When the buyer does come to you and tells you, hey, I'm not bringing you the check, and I'm never bringing you the check, and I'm not going ahead with the deal, they've given us now the roadmap and said we're not closing, okay? If this happens to anybody in the room, on TV, what you're going to do is you're going to tell your client immediately you need to go to a lawyer, whether the buyer or the seller. Buyer says, I'm not closing, too bad. Seller is now stuck in this deal. You're going to go to a lawyer because we have to write a letter now to the other side saying, we understand you're not closing, we're going to have to resell the property, we're going to have to sue you for damages, et cetera, et cetera. That has to come from the lawyer's end. Now, sometimes the buyer defaults and doesn't go and retain a lawyer, okay? If we're the seller's lawyer, we're going to serve it onto the buyer's agent, the buyer's brokerage, just so we have somebody to serve it onto because we have nobody else to reach. So this is where also early on in the stage where they're acting for buyer and seller, it's really nice to know who our client's lawyer is and who the lawyer on the other end. If I have an offer day and I have 5 offers, when I'm going to accept an offer, I would love to have ideally the lawyer's information as soon as possible in the equation for these kind of scenarios, okay? So just watch out for that. When you are selling and the buyer presents you an offer, read what it says. I've seen some funny ones that have gone through. So for example, deposit payable to seller. Have you seen that? No, it's not going to fly, right? It's going to go to seller's brokerage in trust. You're going to have a private deal, and you're going to say that I'm not the agent in this. My client's doing a private thing. I'm not involved, but I am involved, but I'm not involved. Speak to your brokerage immediately. Speak to us because it gets kind of murky here where we're trying to do non-commission deals off the books, and we're trying to circumvent, but there are agents involved. Not the best idea. There's a reason why you're in place, why you are getting paid. From an insurance perspective, from everybody's protection standpoint. So make sure where the deposits money are lying, everybody's information is there. Even when besides filling in where the deposit's going, putting in contact information for the buyer's agent, seller's agent, you know where it is there on page 2 at the top there. And then contact information for the seller buyer on the signature page at the bottom. Go to the time and actually fill in all the information. If the other agent has not filled in, reach out to them, say, hey, you didn't fill in your contact info. Because you'd be actually shocked, in this day and age, do you know how many times I have a realtor I'm dealing with and I can't find their contact information? It's like this giant mystery. So they have no page on their brokerage website, okay? There's a phone number on Realtor, wherever it's at. And when I finally find a page for them, I have to fill in the information, but there's no email address. We need contact information for all the agents, please. Irrevocability, this is a game which people try to play and not one that I advocate for. Don't leave things to the last minute. Don't pass the irrevocable date. Don't go back and backdate it. There's trackability of everything, especially if we're using DocuSign. We know what time it was signed and stamped. And everybody here is using DocuSign pretty much? Is anybody going and handwriting them and faxing it to a place and receiving the fax paper and doing it by hand? No? That's done, right? You know why that's done? For scenarios where we would go back and forth in the fax machine and one person has an accepted offer from try number 7 and somebody amended the fifth offer and got that signed. So we've had scenarios where there's back and forth and you have too many versions out there and you have 2 signed copies. One has certain amendments, one has the other amendments, and we don't know which is now the valid signed agreement. That has happened in the past. This is what we're trying to avoid. And now with the trackability of everything, that shouldn't be an issue. But again, if we're going to pass the irrevocable date, we need to be proper about it and get it restarted. So either you're going to put a clause in the agreement saying that both parties agree that this deal died, but it is alive, or you're just going to kill that deal and sign a whole new deal. But don't go past the irrevocability and think it's still a valid deal. This could be an issue. And people are very fixated on that irrevocable date, but then they're saying to me, okay, but we're going to make a couple of changes here. The irrevocable date only matters if you're going to accept it the way it is. As soon as you make one change to it, like even in the chattels, we're going to get the bar fridge. Crossing out the bar fridge and initialing it is now a counter offer. So you have not gone and accepted the offer the way it is, except for one change. You'd be shocked how often this happens. So I'm going to throw it out there. I've had this scenario where that has happened, okay? And nobody paid attention to that bar fridge getting crossed out initialed. Why? Because the other side didn't see it and thought it was an accepted offer, right? So now we're coming time closer to closing and we're saying, oh, wow, so there was a change there and that didn't get accepted. So how would you treat now this offer? Is it alive? Is it dead? Are they deemed to get the fridge, not the fridge? Where would you go with it?
One question, was that signed, like initial, or just crossed and no initial?
So let's say the last offer came to the sellers, the buyer's offer. The sellers signed everywhere, a confirmation of acceptance everywhere. All they did was they crossed out the bar fridge, initialed it, and buyer never initialed that.
Oh, the buyer never initialed that, so
Invalid.
that's invalid then?
It should be invalid, right?
Yes.
So I remember this exact scenario, and I'm talking to the sellers at this point. And I said to them, well, we got a couple options in life. You can forget about the bar fridge and move on with your life. Or you can push for the bar fridge knowing that they never accepted that, and actually now you countered offer them, and this is not a valid deal because they never accepted your counter offer. So in that case, the sellers did let go of the bar fridge and moved on with their life. But these kind of scenarios can come up time and time again, and this is where not to rush, go through the agreements, and seriously, do it twice every time and make sure initial, everybody's followed along. Make sure nothing is missed. I know even in the electronic age, it's easy to think that we didn't miss it. Do it, double check it. And if you are old school, print off the paper, have it next to you, and mark it off for yourself. Whatever system you have, but you have to double check to make sure every initial, every signature is there to make sure it's valid. Make sure on your dates, and if there's an irrevocability and you are going to accept it, get it in time. Don't lapse it. And call up the agent and say, listen, you know what, my computer broke down, so we're going to deem that it's accepted, and I'll just send it to you an hour or two later. Like, don't leave things like that to the last minute, because we have these kind of scenarios, and all of a sudden the seller says, you know what, a buyer came in with $20,000 more, you didn't accept by the timing, too bad. So if we have a scenario though that there's text messages, emails saying, yes, we accepted it, we're gonna wait for you, this gets problematic, and I've had scenarios like that. And now the seller's agent is saying to me, my client's getting mad at me because they want the $20,000 offer. I went ahead and accepted the other one, but I really didn't get their instructions on that. I just thought it was okay. Be very careful with it. This is where, again, everything in writing. So if you are going to let things lapse or you're going to deem to accept it and you're saying, okay, you know what, you're in the car right now, you can't send it, pull off to the side, send me a text message, send an email, make sure your clients are okay with that.
So a situation whereby the seller is on the other side of the globe, let's say it's in Asia. So irrevocable will be a local time and date here. So what does it mean when the seller receives it on the other side?
They better have their iPhone world clock and be knowing what Toronto time is.
So it's still the local time that...
Well, because think about it. Otherwise, let's say I'm aware of this. I can jump on a plane, go to Arizona, be a couple hours off and say, okay, deemed to accept it. You know, whether the person was there from the beginning or went there, they know this deal property's in Ontario, we're on Ontario time. They have to make sure they send it in Ontario time. Going back to court decisions and issues. So this one has also been a giant problem to be very, very careful about, and its completion date and what that means. And there was a builder that said to the buyer, I understand you went to the bank, you got your mortgage, I understand you're on your way to go deposit the certified check to me. And guess what? It's 4:59, it's now 5 o'clock, I don't have your money, so deal is dead, I'm gonna sue you for the deposit, damages, you're donezo. Court came back and said to the builder, no, that was very, very bad of you because you knew they had the money, they showed you a picture of the certified check, and you could have given them a little bit of leeway, would have been in your account by 6 o'clock. You could have closed an escrow and registered the next day. That was not cool. You have to give some leniency, so the timing is not exactly to the minute. But other courts have come back and said, well, you didn't close at 5 p.m., 6 p.m., whatever the timing is. And read the agreements, by the way, because it's not always set time. Most of them say 5 o'clock, sometimes it's 6 o'clock, so just watch the timing so your client is aware of it. But a court could hold them to the timing and saying, look, you were supposed to pay this money by this date, you didn't. We don't know when you're going to close. You're saying that your mortgage monies are not in, but at that point, the money's not even in your account. Maybe it's coming the next day, maybe it's not. I don't think that the seller should have to wait for you and sort out your mess. So what that's telling me is if you're a buyer and you're not ready to close on the day of, be prepared well in advance. Make sure you get your mortgage broker in place. Make sure you're getting your monies in place. And don't leave to this kind of situation. If you created this mess where you rush the deal and you put an offer in with a quick 2 weeks, 3 weeks closing, you don't even have a firm commitment from your lender, your seller is under no obligation to extend the deal, okay? I know that people get upset when they're saying for a 2-week extension, the seller wants $20,000, they want additional $200,000 non-refundable deposit, whatever it is. The seller can do pretty much whatever they want at this point. They're saying, look, we have a deal, you're not honoring it, this is the only way I'm gonna agree to stay in it, and if you don't like it, then you're out, and I'm gonna go relist the property, and then I'm gonna go and sue you. Pretty simple.
And keep the deposit?
So, depends on what the agreement says, and depends on what our scenario is. So one of the things are, what happens to the deposit? Now, if I'm the seller and a buyer comes to me for an extension and says, look, my mortgage isn't through, I need a month. Maybe I'll close earlier, but give me a month. I'll say to them, no problem. So you have a $100,000 deposit already in place. You're gonna give me another $100,000 deposit. All of it is now non-refundable. If you don't close for any reason, the money goes immediately to me as a seller. I don't need your consent. I don't need a court order for it. And I can still sue you for damages on top of it. We have to have that explicit writing. Both sides have to agree to it, and both sides have to sign on it. It's not sufficient to have that just as a clause in the agreement. You're actually going to have a signature just for that one portion that both sides agreed that in the scenario that the deal doesn't close, that the seller gets to keep the deposit immediately. Because we have the situation, remember, the money is sitting with the brokerage in most cases, or sometimes it's in a lawyer trust account. We're not releasing those monies unless both sides give us a signed agreement or we have a court order. If you give me this agreement and it says you can release the money, no problem, it has to say in there that the buyer and the seller irrevocably authorize, direct the holder of the deposit to release the monies with no liability, both sides indemnify them. We have to have all this kind of language, otherwise the deposit's not going anywhere. So completion dates are not all created equally. And I wouldn't be the buyer or seller as far as taking a risk with this. I wouldn't say, you know what, I had the monies, and seller, if you're not going to extend me by 1 day, fine, we'll go to court, I'll win. We never know what a judge is going to say for certain. So it could go 50-50 really the way it based on what I've seen from the court decisions. So the closing date, the completion date is in stone with exemptions. So be careful. And I always tell either side, if you need to extend the transaction, you have any kind of inkling that you can't close, ask for it immediately, work your way. Like there was one person was selling their house, couldn't sell their house. They had new construction coming up, a purchase, and they're saying, maybe it's gonna sell in a month, maybe it won't. When should I come to the builder and ask them for an extension because I don't think I'll be able to close on time? I'll tell you, the day before the closing is not the best time to do it. If you think you need to go on your hands and knees and beg for something, do it early in the process. It shows a lot more respect to the other side. The later you wait for it, the more aggravated they get. So far, any questions for anybody?
There's one on the chat.
Maybe off topic, but curious. My realtor friend listed a property with mixed use, residential, commercial. She asked me if I can find any buyer for her listing. I asked a few due diligent questions regarding property, like latent material, latent defects, conditions, etc. I asked if she had an SPIS. I asked her about the cap rate and as it has a commercial use as well. Her answer to all my questions was this: I have to protect my seller and my buyer's agent. It's your client and your responsibility to perform property inspection and put a condition in the APS. My question to you is she complying with TRESA, RICO, Consumer Protection Act, and other applicable legislations?
Yes,
Sorry.
Somebody was in their real property law course and is remembering now flashbacks from it. Look, it's this is part of a presentation we do as far as the new requirements for disclosure, not disclosure from a realtor point of view. And one of the things is made clear is if you're acting for a seller and a buyer's agent comes to you and says, I have a bunch of questions, if you're acting for the seller, your first responsibility is to go to your seller client and to ask them, are you okay with me disclosing this information? If you go and disclose a whole bunch of information without your seller consent, you actually could be overriding your responsibilities to your seller client. But that being said, and there's been recent, I just read in the paper the other day about this. I think it was out, it's always out in BC, by the way, but maybe it was in Alberta. But they do funny things out there. But you're aware that your seller is, this is it. The seller was actually the agent as well. They knew there was foundational issues with their property. They got a sloppy job to cover off the foundation cracks, never disclosed it, and then had a whole bunch of issues. That's a little different because, as far as patent latent defects and how that works. But as an agent, in most cases, you're not the seller and the agent in that case. If you're aware that there are actual issues with the property the seller made you aware of, or you see it from your own inspection, and you are supposed to disclose it and you don't disclose it, and your seller tells you not to disclose it, your main thing then is to walk away from the property. Say, I can't list it anymore, I can't work for you anymore. You can't do a cover-up with your seller just because they tell you to do that if it's something illegal or something that from a fraudulent perspective should be disclosed to a buyer. So be very, very careful of it. Your back should be up on the wall immediately when you are acting for the seller, and take down the questions, come to your seller, say, are you comfortable, not comfortable with it? And if you think it's something illegal, immoral, what be it, check with a lawyer, check with the brokerage beforehand. And we have sometimes these scenarios, and I know it's hard to do this, but it's better to walk away from a transaction and listing it than going ahead and listing it and then having a court decision against you. So I hope that answers that person's case. Title search date. People generally put 2 weeks before the closing, fine. what you need to know is not all law firms are created equally. So for example, when we're acting for a buyer at Corman's LLP, what do? I get the deal in, you send me a deal, and it's closing in 3-4 months from now, and the title search date is 2 weeks before closing. Most law firms are not going to search title to 2 weeks before closing and then send the requisition letter. What we do is, which is kind of funky, we actually check the PIN and we search a title when we get the agreement in. And why do we do that? Because there can be a whole bunch of funny stuff sitting on title, and we let the seller's lawyer know, we just searched title, here's the PIN, there's a bunch of problems here, but we're closing in 3 months, this gives you enough time, deal with it. You'd be shocked at the kind of things that can come up. So property is subject to a spousal interest. So people were getting separated, divorced, only one spouse is on title, they didn't put the other spouse down as consenting, the other spouse went and registered something on title, so that means they can't sell the property without that spousal being dealt with. An old mortgage sitting on title. So I had one where there was an old VTB, vendor take back mortgage, when they sold the property in 1950 for $35,000, $40,000, and they got a full VTB, and they never dealt with the VTB. So they even had refinances since, and that old VTB was sitting there. And it took me 3-4 months. I had to track down the original seller. She moved to the Yukon, and she was like very apprehensive of who I was. And then it took me a while to explain of what we were doing here. And like we had to get, I don't know what you call them, not a headhunter or a bounty hunter, but anyways, there are people that can find people, let's put it that way. If she's had a driver's license, a credit card, I'm gonna find her. It is like the movies. So I did track her down. She did agree to sign the paperwork. We got that old mortgage off. But sometimes, I don't know if you've ever heard of this, a bank buys out another bank, a bank goes bankrupt, whatever, but their mortgages are still sitting there. And then you come to like TD and you're saying, hey, Canada Trust Co., you have a mortgage from 1970. Oh, that's another department, and don't worry, it's a lot of hoops to try to figure out who's responsible for that. So we need that time to deal with these items. If there's building and zoning search we find out that there's open permits. That happens quite a bit. Now, not everybody searches open permits, just to be clear. So we have title insurance, and we've had separate presentations just on title insurance. But let's say I buy Jim's house, and Jim, has a swimming pool and a gazebo and a deck, and Jim's got a lot going on in his house, right? Jim applied for a bunch of permits, closed 90% of the permits, but there's 2 open permits sitting there on Jim's title. Sorry to pick on you, Jim. And Jim may not be aware. He had a contractor, and the contractor said, yeah, everything's cool. Well, if I search title for my buyers buying Jim's property, and I see this open permit, I can come to Jim's lawyer and saying, you know what? We don't have to accept title to these open permits. You need to close them immediately. So, but there are times that lawyers saying, you know what? We have title insurance. We're not aware of any recent renovations. It's not a funky property, so we're not going to search. And then if there's an open permit that comes up after the fact, title insurance will look after that for us. But I've had scenarios, I've had clients that have sold a property, and when they bought it, there was open permits from back then, nobody was aware of it, and now the lawyer for their buyer has found this old permit from the old seller, and we got 2 weeks to go from closing. Any idea on how I got around that and closed the deal? You're gonna love this one. So title insurance comes to us and says, look, we're good people here at Title Insurance. We try to help you. So you're going to contact your buyer. Your buyer is going to agree to buy title insurance through us. So we keep the continuity. We're going to give an undertaking to deal with that open permit. It's our problem, and still allow you to close. So there are ways around it. So every scenario we kind of have to encounter depending on the situation, but we got this title search date sitting out there. And if we don't give ourselves enough time with it, sometimes we run out of time.
My question is, with this open permits,
Yes.
does it not get expired with the passing of time? Say, somebody has not done anything with that permit. It was issued, they wanted to do some changes, but they didn't do it.
Those are lovely. Yes, absolutely. I had this aspiration, I'm going to rip out my whole backyard, I'm going to make all these fancy changes. I went and applied for the permit. I woke up one morning, I said, you know what? Yeah, it's not for me anymore. I'm just going to leave it. And then we go to sell the property and we find out there's an open permit. It's very clear. It says there, for questions on this permit, contact this inspector. So on the permit, it says who the inspector is, their phone number. Takes sometimes a little bit of digging. Sometimes they pick up their phone right away. Sometimes they're on vacation. Sometimes they're busy. But eventually we get a hold of them. They've left. We find the next. Somebody is going to search into that property eventually. And they're going to come back to us and say, oh, turns out they never did anything with this. You're right. They applied for a permit, never dealt with it. Great. Can you close it? At the end, can you give me something in writing confirming that? And that's it. It's done. Easy.
Hey, John,
Yes.
Can you go back to the completion date?
Oh, sure.
So this is the case whereby the seller is a non-resident. During closing, the seller advised the buyer's lawyer, the seller's lawyer advised the buyer's lawyer to withhold 25% of the proceeds because of the non-resident certificate of tax certificate or something?
Section 116 clearance certificate, CRA.
Yeah.
So in your example, Jim, we find out a couple days before that the person is a non-resident, right? So seller's agent effed up on that one pretty badly because they should have known their client right away, should have disclosed that so the buyer could deal with it. Because what happens is we requisition, if we're acting for the buyer, we're going to requisition the seller's lawyer. One of the things we're going to say is, we want you to sign a declaration saying you are a resident of Canada for tax purposes, or tell us you're not. If you read, so there's a giant misconception about the Section 116, we can talk about that. If you read the standard verbiage inside the agreement, what it actually says is not that there's the ability to withhold. It's that the seller is going to give the money to the buyer and the buyer is going to remit that money required to CRA. But there's an issue with that because if it was their permanent residence, the seller, it's 25%. Everybody thinks it's 25%. But if it was an investment property, it could be as high as 50%. And this is a giant issue. So in a perfect world, we know about this early enough. So if I'm the seller's lawyer and I'm aware that my seller is a non-resident, then what I'm going to ask Jim is, okay, I need this clause put into the agreement where it allows the seller's lawyer to withhold the required money, 25%, whatever, until such time as the clearance certificate is received. If we don't have that clause in there to protect the seller can rely on having the holdback. If the buyer's lawyer insists on the money being remitted on closing, then that means the seller has to give the money to the buyer's lawyer has to remit it to CRA. So it's a bit of a headache. And these have come up a lot as well on assignments. So one thing I'll say about assignment deals, if anybody here, because the nature of the brokerage, you have new construction, right? I will tell you that a foreign seller of an assignment deal is a giant pain in the butt because now you have clearance certificate issues and we have HST issues and how we're going to get that money and how we're going to chase them to remit the HST and remit for the clearance certificate. So this is where we have to have holdbacks. We have to have some sort of protection measures.
So in my case, I'm on the buyer's side. So the seller's lawyer advised the buyer's lawyer to withhold 25%, pending receipt of the certificate of the tax certificate.
And if I'm the buyer's lawyer, I'm going to tell them, go fly a kite, read your agreement. There's no provision at all for me agreeing to a holdback. It says you're going to give me the money. You're giving me the money. That's all there is to it. And why is it that the buyer wants that? They want to protect themselves because if they don't have that money and they don't have the clearance certificate and they don't have the signed declaration from the seller swearing that they're a resident of Canada, the buyer's on the hook for the money. But from the seller's point of view, they're saying, look, I'm going to apply for the clearance certificate. I've talked to my accountant and the amount I'm going to owe is less than 25% because of the monies I spent on this and my costs. The buyer's going to say, look, I don't care. I don't care what the actual amount is. I'm remitting it to CRA and you can go ask CRA for a refund. So depending on whether you're the buyer or the seller, it's a very different consideration. And one thing I will tell you is if you put that clause in for the withholding and protecting the seller, don't reuse the exact same clause when you're acting for the buyer. People love doing that for some reason. They have these clauses. They're like, this is a great clause. I used it in the prior deal. I'm going to use it in the exact same scenario. And I'm like, but you're acting on the other side now, and this is not protecting your client at all. And this is where reading your agreements is very, very important, reading your clauses. I've had ones where we're talking about assignment deals, Jim, and there's like 2 or 3 different options of how to deal with HST and withholding, etc. And people just put in all the clauses. I'm like, yeah, but it's clause 1 or 2 or 3, not all 3, because they contradict one another. Now, which one is the valid clause? And you've all seen this, right? Where people put in a vacant possession clause and they put a little more elaborate and then they put a different vacant possession clause. Don't allow for that. One clause for one issue and get rid of the rest. Keep it simple. And which clause are you going to use? Use the one that's most in favor of your client. Pretty easy. So that's on title search. Agree and accept title, we talked about accepting to permits, not permits. If you are aware that there's an issue with this property and you're acting for the seller, you need to disclose it. If it's on title, if it's something substantial. You know there's a major easement running through the property, there's a major right of way, disclose it. Survey, I would tell you, one of the things I love doing personally, you know there's a survey, you got to copy the survey, just attach a Schedule C. Do not put in, let the buyer put in the clause that the seller is to provide an up-to-date survey showing the current location of all structures and a declaration there's been no changes to the property since the date of the survey. Because you give that old survey and there's been any changes to the property, the buyer can come back and say, you didn't give me a valid survey. You didn't give me the current location of everything. This survey is no good. You're giving me a new survey now, or you're paying for my title insurance. The easiest way to do that is if you're the seller, cross out the clause, say seller, including survey as attached as Schedule C, and call it a day. But if you're asking for the buyer, of course you want an up-to-date survey. Why wouldn't you ask for it? So again, thinking about those items. Okay, residency, we talked, that was a good point as far as it comes about. If you're acting for the seller, find out right away, are you a resident of Canada for tax purposes, Section 116. People are getting very, very confused with foreign buyers and foreign sellers. It's very different considerations. I live in the United States. I've lived there for many, many years. I'm a Canadian citizen. I can buy Canadian properties all day long and pay no foreign buyer tax. But I'm the same person, and now I'm going to sell. The fact I'm a Canadian citizen is irrelevant because I haven't been filing my taxes in Canada, so I'm considered a foreigner as far as selling purposes. If you are acting for the seller and you have a buyer coming with their agent, ask the agent, is your client a foreign buyer? Did you verify that? Did you double check ahead of time? And if you're the buyer, ask your seller, I've come to the property, I see it's empty, I heard it's rented. Is the seller a foreign seller or not? Find out this information ahead of time. Good things to know. Second story. Okay, and we talked about time limits a little bit. Again, don't take anything verbally for gospel. So you call up I've had these ones way too many times. Call up the other agent. Listen, we're going to need an extension. We just need 1 day. Are we cool with that? Yeah, I don't see a problem. That should be fine. Just go ahead with it. We get nothing in writing, and all of a sudden the lawyer gets a scary letter from the other lawyer saying that nobody's agreed to extend the transaction, you're in default, blah, blah. If the other agent is amenable, get it in writing right away from them. If they did not get instructions, that's their issue, but make sure you get in writing for something, anything. Once, and I would say, I hate to say this as a lawyer, but it's true. Many times realtors say, you know what, I'm not going to deal with the other realtor. I'm just going to let the lawyers deal with it, right? You'd be shocked how many times Jim can do an amendment, send it to the other agent, get it signed, and we are good to go, versus sending it to the other lawyer, and now the lawyer comes back with a whole bunch of clauses and conditions and protections. So if both agents are amenable to something, like something simple as changing a closing date, for example, just do it. Just get the amendment chain, send it off to the lawyer, be done with it. Otherwise, you're going to send it off to the lawyer and they're saying, yeah, they're agreeing to extend the closing, but they want an extra $100,000 deposit, Jim, and they want damages. You're like, oh, why didn't I just send it to the other agent directly? Don't be afraid to do that. It doesn't mean they're going to agree to it, but it doesn't always hurt you. But get your client instructions, obviously, and never hurts to have them speak with their lawyer and making sure. So very often, like Jim's telling me, for example, oh, I can't locate the other agent all of a sudden. What am I going to do with the transaction? You're going to write to the other agent in writing, and I'm going to write to the other lawyer in writing, and we're both going to do it. Things get done a lot quicker if the agent writes to the agent, the lawyer writes to the lawyer, if we're all doing everything at the same time. Friday, 7 p.m., 8 p.m., I get an email last week, true story, okay? And says to me, you know, the seller isn't out of the house, and we closed, and I see things there, and the other agent took the lockbox, and there's no keys now. What are we gonna do? What we're not gonna do is just leave it to the lawyer and call it a day and hope everything works out on the Monday. If I was the realtor on that, I'm on the seller's realtor immediately and put it on them. Where's the lockbox? Where's your client? Why aren't they out? What's going on? And so I actually wrote on a Saturday to the other lawyer. I said to the agent, write me a whole list of everything that's wrong, what's going on. I'm going to forward that email and tell them we want answers immediately. We're both going to do this. But very often you're going to reach a lawyer on a Saturday, Friday. Good luck in reaching them, right? And what we don't want to do is leave it and hope it works out till Monday. When the washing machine is not working, it's broken, the air conditioning is broken, the roof collapsed, whatever it is. You have to understand, you know how you have the warranties that the house is going to be in good shape, the child and fixtures are in good working order? Well, as soon as that deal closed, it's a ticking time bomb. Because, why am I saying that? Because let's say the deal closed at 3 p.m. and the property was in good shape. And then we get a giant rainstorm at 7 p.m. Massive, massive rainstorm. Now the clients come to the house for the first time the next day, 9 a.m., and they're saying, the basement is flooded. Sellers should be responsible for this. What would you say if you're the sellers? I left you the house in perfect condition. It's not a brand new house with Terry on. It flooded at night with the giant rainstorm. That's not my problem. Now we don't know, did the rainstorm cause it or was it there already? This is where the sooner we know there's an issue, the sooner we should put it in writing. So if you know on Friday at 5 p.m. that there's an issue, get it in writing to the other agent, forward it to the lawyer. We don't want to be writing for the first time on Monday because now they're going to tell us this happened over the weekend. It's not our problem. Can't tell you how many times clients bought a house, decided to go on vacation right before closing, came back 2 or 3 weeks later, and they're like, oh wow, dishwasher's not working, there's a hole in the ceiling, there's a wet spot. I'm like, so? Was it there on closing? Well, I don't know, I was gone for 2 or 3 weeks. Right. Every second that is ticking by is a problem. I say within hours is okay. As soon as it's the next day, it's iffy. And every day that goes by, it's worse and worse. So if you are not going to be on closing, you get somebody in there if you're the buyer and get the property checked out and give notice to the seller as soon as possible. You come back to the seller any later, it's an issue. And Jim, swimming pools, right? We love them. Everybody loves, having a swimming pool. It's great. But we don't live in California and we don't live in Florida, okay? Although we can't really say Florida right now because of what's going on there. But in all seriousness, I've done so many swimming pools in my time, and there's a whole thing about, was the swimming pool closed properly and winterized? And then when was it opened properly? And there's always an issue when it comes to swimming pools. So there's a whole bunch of clauses we need in there. If we're a buyer, seller has to watch it. I would say at the end of the day is know that you need to protect your client with it. Don't just put a one-liner and that's it. Simple little things like that. Even something like assuming a tenant. This has come up to me 3 times and I've given agents a lot of crap about this. So you have a property, it's a condo, there's a tenant in there, buyer is buying it and assuming the tenant. Should be very, very simple, right? If I'm the buyer, I don't want a one-liner saying buyer agrees to assume tenant on closing and that's all there is to it. It doesn't work like that. Because when I'm coming in now as the buyer's lawyer, I'm saying, you know what? I want the landlord, the seller, to sign a declaration with their lawyer saying that there's no issues with this tenant whatsoever, the lease is in good standing, there's been no problems at all. I also want the tenant to sign the same thing. So I want some sort of tenant declaration, and I want to adjust the rents and the deposits, etc. We actually need clauses for all this stuff. So if you are used to doing residential, not doing commercial, and you encounter anything with a tenant, talk to your brokerage, talk to a lawyer immediately. Don't just put a one-liner saying, we just assume the tenant and that's it. Because that buyer assumes that tenant and becomes the landlord, and there's an issue with that tenant and then something going on with the tribunal, without any kind of indemnification declaration, that buyer's on the hook now as the new landlord for any previous issues with that tenant.
But you cannot adjust the rent. You're assuming the tenant, you cannot adjust the rent.
I wanted saying in there that we're going to adjust prepaid deposit, interest, all that. So I actually want to have all that verbiage in there, exactly. So you're a buyer, you're acting for your buyer's agent, you're acting for a buyer that's going to assume a tenant. It's no different to me if we're assuming the condo with one tenant or I'm buying a multi-unit res and I have 20 tenants in there. I want the same kind of deal in there to protect my client, the buyer. But on the same token of it, if, again, remember what side we're acting on. If we're acting as a seller now, we may not want to put the same clause in that we put in as a buyer, because guess what? Let's say you're buying a multi-unit res and you're buying 50 units in there. You know how hard it is to get 50 tenant acknowledgements? Next to impossible. So if we're going to even agree to that, we're going to agree to use best efforts to give you that acknowledgement, but we can't guarantee it. If I'm the buyer, of course I want it. Family Law Act, time and time again about family law and spouses, no spouses. You're acting for a seller, and your seller is extremely shady, and you're not feeling really good about the seller and what the property is going on. I don't know what mortgages they have on there. Will they have enough money to close? Is there a spouse, no spouse? Call me. We'll pull up title for you, and we'll search, and we'll tell you, okay, this person is selling this property. These are the registered owners, and this is the mortgages we're seeing. And looking at the old transfer, there was 2 people before, so it looks like there was a spouse. Whatever it is, there's a little bit of digging you can do sometimes when you're acting for the seller. It's things you may see above Jewel Warehouse. So a seller's agent that is being extra cautious, sometimes you talk to the lawyer and you'll see what the title looks like ahead of time, could save you a lot of aggravation. If you see there's 3 mortgages, a CRA lien, there may not be enough money to close. There may not be enough money to pay the commission. If that's the case, why even bother, right? Like, anybody here want to work for free? I don't. Family Law Act, if there's a person in the house, when the person, I'm the owner of the house, come, I'm going to show you my property, and you're like, okay, who's this person? It's my partner, it's my better half, whatever they call them. Are you legally married? And they're like, well, My favorite appointments is when I'm acting for 2 buyers and we got to sign the mortgage documents, and I look at them and I tell them, so, are you legally married? They're like, can I just call my mortgage broker for 1 sec? And they go call the mortgage broker, they come back, no, we're not legally married. So, did you have a ceremony? Did you walk down the aisle? Was there a ring? In my country, it's different, I'm not sure. And then, okay, that's fine. What's your occupation, by the way? What's your job? Let me call the mortgage broker once more, because my English is not very good, so I don't know what to describe it exactly. It's amazing. Did you ever own property ever anywhere in the world? Oh, in my country, it's different. I don't know if my parents put a property in my name without telling me. I'm not sure, like we hear it all, do it all, but if you have that person in front of you and they're telling you it's a spouse, quasi-spouse, you're not sure, just get them to sign off as consenting spouse and let's call it a day, okay? Let's just make life very, very easy. Too many times, people are not getting the spouse to sign off on the agreement, and then all of a sudden we get a nasty phone call from a person and their lawyer saying, I'm the spouse of so-and-so, I just found out you're the lawyer for the seller, I'm the spouse, just so you know, I'm registering my interest on title now, and you are not allowed to close this deal because I never agreed to this transaction. And this all could have been averted if the seller's agent simply had asked them, are you a spouse or not? Now, there's a difference between common law spouse and legally married. This is one of the few differentiations. So we need to know legally married in this case for property interest for consenting spouse to sign off. When you have people buying and it's for land transfer tax purposes, then common law spouse, relationships of permanency where they have a child together, all that gets more encompassed. But the purposes now of being able to sell, we need to know if they're legally married or not. And if in doubt, just get them to sign it, please. They're there and they're willing to sign, just sign it.
Common law is not considered?
If it's not for the purpose, if I am common law and I'm going to sell my property, as of right this minute, no, I don't need my common law spouse selling off. It's actually shocking if you think about it, because they've encompassed common law into every other definition of spouse. I'm shocked it hasn't.
Family law.
For family law purposes, yeah. and encompass like related in terms of property goes. Like every single taxation point of view, spouse includes common law, except when you're going to sell the property.
Hey, Jonathan.
Yes.
When the seller is the estate, so this one is the estate of the, I guess, the deceased. On the offer document, do you have that name, the estate of the deceased, and somebody else, or just the estate of the deceased is okay?
So
The listing shows only the estate of somebody.
is there two people on title or just one person?
Just say the estate of.
So let's say John Smith is the owner. John Smith has passed away. Estate of John Smith is the one that's a seller.
Correct.
Yeah.
So on the offer, you write the estate of.
John Smith, yes. And then what the seller's going to do is they're going to get somebody to sign off and they're going to put as per executor and put the person's name. But for your purpose as a buyer, you're just putting estate of John Smith as the seller.
So you don't need to put an executive name as well, right?
Typically you don't, but they'll add it in because you don't know who the executor is often and get them to do it. If you hear somebody selling by estate, if you hear somebody selling by power of attorney, whatever side you're on, ask for a copy of the power of attorney immediately. Don't pass go, don't collect 200 until you see the power of attorney, and get the copy of the will, make sure everything's in place. Now, when we start getting into estate sales, we need to know, this is so messy now, if we're gonna need to get probate done and probate hasn't been done. If the person comes to you and says, Jim, listen, we already got probate done, here's a certificate of the court, we're good to go, those are the easy ones.
Can you explain probate process?
Okay, so we got John and Mary Smith, okay? John and Mary Smith, loving couple, own a house together. John passes away, they held the property as joint tenants. Now Mary Smith is the owner, the end, easy, right? Mary passes away now, she's got 2 children. Mary never added her kids to title, so now this property is in limbo in most cases. Now, if we go and search title and we see that Mary's owned this property for the past 30, 40 years, never had a mortgage, never done anything with the property, we could circumvent and requiring probate because we'll say the property's never been touched on the title's end of it, so we can actually, now the estate can still pass it through without requiring a certificate from the court. That's rare. Most properties, it's been bought, sold, easements put on, mortgages put on, whatever being, and we require a court certificate. So what happens with Mary's estate, we're looking, okay, Mary bought the property 10 years ago when it was already in land titles. We can't circumvent it, we're gonna need a court certificate. So we go talk to Mary's children. Are you gonna apply, does Mary have a will? Mary has a will, we gotta look at who is the decision makers and who's allowed to apply to the court. If Mary died without a will, then somebody has to step up and say, look, I wanna be the executor and I wanna go apply for Mary's behalf. The process is the same where we apply to the court for probate and we ask for a certificate of the court approving them to be estate trustee. In that application, we put down who is the executor, who are the beneficiaries, in this case it'd be the 2 kids, let's say, and we put in what the value of the estate was at the time of death. So Mary's estate is going to have to go and get a realtor to appraise the property and say, on the date of Mary's death, what was this property worth? Did she have any other investments, any kind of holdings at all that do not pass automatically to the kids? Because like, let's say you have life insurance, you have bank accounts, you have RSPs. If there are named beneficiaries, it's just going to go directly to those people. But let's say you have investment with BMO Nesbitt and you have $200,000 sitting in there and there's no named beneficiaries, they're going to need a court certificate. Anything where they need a court certificate to give you the money or the property, those have to be put into the calculation because now you're paying a probate fee, a tax fee. And there's an escalating scale based on the value of the estate. So it goes from 0.5 to 1, 1.5. So you got to calculate this out. At the time of application to be for the court certificate, you have to pay the tax upfront. And then it's a waiting game to see when the court will sign off and send back the certificate. Without that certificate, you cannot close the transaction. Can't close the transaction.
It's amazing you're paying tax on after-tax dollars.
Absolutely. But it's funny because people saying, okay, I'm going to be smart about this. What I'm going to do is I'm going to get my mom, Mary Smith, gets her 2 kids to add them onto title. So now they own it. Mary's passed away. They're like, great, I don't have to pay the 1.5%. Fabulous. They keep the property, but they're not using it as a primary residence. And then when they go to sell it afterwards, they're going to pay capital gains or business income, which is a lot more than would have been paying the probate. So very often it's funny because people tell me all the time, I want to avoid probate, just add me to title. I tell them you have to go an accountant and you got to calculate all the possible scenarios, because if it was Mary Smith's house and she sold as an estate as a primary residence, there's still no capital gains there. You're better off paying the probate of 1.5% than you are paying 35, 45, 55, whatever it is in taxes there. So there's a lot more planning that goes involved. But when you do that kind of planning, you're doing it based on today's tax rates. Things could change in the future, right? Like, for example, we have an election next year. The powers to be may change, possibly. And when they do, the taxation could change as well. So all you can do is make the best plan you can at the time of the planning.
So who legally owns the property in that interim?
Mary Smith, it's still in her name.
But she's dead.
Nobody can pull it out of Mary's name unless we had that one exemption. Otherwise, what happens is Mary's two children, let's say there's no will, they decide to be the executor together, but if one decides to be the executor, they have to contact the other beneficiaries potentially and make sure that they're in agreement with them being the executor. The other child may say, you know what, I don't agree with this, and now they're fighting over who gets to make the decisions. It can be a whole freaking mess. This is why it's a good idea to have a will and to stipulate who you want to make the decisions, how you want things divided up. Doesn't mean they're not going to fight, but at least there's some sort of groundwork so there's less bickering, theoretically. Once they get that court certificate in, now Mary's kids can go and close the deal. Remember I talked about you can't close the deal. I didn't say you can't list the property. I didn't say you can't sell the property. So Mary's kids could go ahead, list the property for sale with a realtor. You'll say, hey, where's the court certificate? Well, we're in the process of doing that. Go ahead and sell the property, but you have to have a clause in there allowing for an extension of the closing until we get that court certificate. Now, I've had ones where I put in for the seller, if we don't get it by X amount of time, the deal's dead. But most buyers will then say, well, what if the property value goes up? You could just stall us theoretically and then go sell to somebody else. We don't want that. So that's where it gets kind of messy. Different consideration if you're a buyer or a seller in that. If you're the seller, what you need to know is you need to be able to extend it enough so that you're not going to be in default. Like, I've had ones in Toronto where it was a rush, property was sold, it's closing in 2 weeks, they didn't realize they needed the court certificate. We got the court certificate in less than 2 weeks, like record time. I had one where it took 14 months. If you've ever gone and stood in the line to get your social insurance number, for your passport, the DMV, imagine what that's like, and that's how getting a court certificate is. It's pain.
We have a question, can Mary sell her property to her kids?
Anybody can do anything theoretically. What I would need to know is there any consideration passing through? So I had one where a person called me up because they're very smart, and they said to me, okay, so I have a mom. What I want to do is I want to gift my mom my house, and my mom at some point is going to gift me her house. That's how we do gift exchanges in my family. So government's a little smarter than that, and what they say is if you trade a house for a house, that's the consideration. Each of you are paying land transfer tax on that. Any consideration means anything passing through. So it can't be, Jim's going to gift me his house. I'm going to gift him a duffel bag with $700,000. It doesn't work like that. That's consideration. So when you gift, it actually has to be with zero passing through. So if you want to gift it with no consideration at all, that's a gift, great, no land transfer tax. What's going to be the tax ramifications now from a capital gains perspective? That they have to talk to an accountant. But as soon as you have a case where mom is going to sell the house to their kids, and let's say for fair market value or whatever being, you need to think that this person is off the street, it's a third party, make an agreement purchase and sale, draft it the proper way. There's no shortcuts in life, because if you don't make that agreement, and I've had these, all of a sudden, mom stands up and says, you know what, you're taking advantage of me. I think that the property's worth twice as much, so I actually want twice as much. Or you know what, I don't want to sell to you at all now. And you're saying, hold on a minute here, but you promised. Well, I don't see an agreement in writing, and I don't see a deposit given. This is a problem. Yeah. I remember somebody was going to sell me their car, and I met them through somebody, their cousin, and we had a deal, and I said, do you want me to send you a deposit, something? Because I was already feeling kind of iffy about it, and he said, no, you know what, I'm just waiting for my other car to get delivered. As soon as my car gets delivered, I'm selling you my car, don't worry about it. And he was a lawyer too. And then he calls me up a month later and says, you know what, my car's not getting delivered, so the deal's off, forget it. It was through the guy's cousin, whatever, but if I was really adamant on getting that car, you better believe I would have done an agreement in writing, I would have given the deposit, and just left a more open closing date. And sure enough, on AutoTrader, about 6 weeks later, I see that car with that VIN for sale in Quebec for $30,000 more than I was going to pay. So the guy got cold feet, thought he can get a whole bunch of more money, and now he's going to do that. But I never made a deal in writing. I didn't put a deposit because I was never going to hold him to it because I knew the guy's cousin and I'm not going that route. But if the kids want to have a deal and they want to do it properly, you put it in writing so we know everybody's responsibility. I've seen families fight over chattels, fixtures, assumption of rental contracts, all the kind of things we fight about with third parties. And guess what? Families are going to fight more over this kind of thing. So that's where just make a deal in writing. Don't take the shortcut, please. Otherwise, we're going to go to court and we're going to say a verbal deal. Is it a deal? Not a deal? It gets really, really messy. Could go this way, could go that way, depending on what the judge rules, what we have in writing already, what's under consideration. Just get a proper agreement. If you're going to buy somebody's parking spot in a condo, so you see an ad and the person says, I want to buy a parking spot, I want to sell it, and the person comes, okay, I want to buy it. Great. You're going to make an agreement, and make a 4-page agreement. I'm buying your parking spot. Here's the price. Here's the closing date. Here's the deposit. No shortcuts. By the way, I own an extra parking. I own an extra locker in my condo building. I sell it to Diana. Diana's got a unit in the building as well. HST applicable, not applicable on selling on the parking locker.
No, yeah, but it's always, it has to have HST, like, yeah, answer please, where all.
Included in.
Yes.
So let's take that exact scenario, shall we? I went to buy someone's parking spot in a condo building. I have lived on this earth for many years. I have never, ever met anybody that ever wanted to pay more money for anything than they needed to in the history of mankind. You agree on a price, it's a price. I'm not gifting you the HST, not going to happen. So he says to me, then we're not going to close. I said, no problem. Then I'm going to register the agreement against title. By the way, if anybody doesn't ever want to close on a transaction from a buyer's point of view, the seller doesn't want to close, buyer says, I'm going to register the agreement on title. So that means you can't sell it now, you can't do nothing with this, I'm tying up your property, and then I'm going to sue you, and then you're going to pay my legal costs for that as well. He goes, for a parking spot. I said, watch me. And he closed. But he had an agent. That's a problem. So if I were him, I'm kind of my agent, how'd you let me sign HST included in? And what are they going to say? Oh, I'm not an accountant, I don't know. You saying I'm not an accountant, I don't know HST, not going to be a very good defense in a RICO scenario, right? As soon as your client puts down anything, you have to have the ability to know there may be a potential for an issue here. This is not selling the parking locker as part of the unit. I had another one, a client buying a boathouse. Okay, boathouse. It's not attached to the cottage. It's literally a slip where you parked your boat. And they said to me, I'm acting for the buyer here, and they said the seller prepared the agreement. I go, perfect. What do they put for HST? Included in. Fantastic. Because think about it, you can't live in the boathouse. It's not used residential, so HST is always, the thing is, the rule is, if you're ever in doubt, HST always applies to everything unless there's an exemption. Okay, and unless it's used residential and physically the property, but even still, without you knowing the property, if you see it's vacant land, if it was substantially renovated, there can always be HST implications. Put your client in writing, check with the lawyer, check with the accountant. Very, very important.
I have a question, like that parking spot paid HST already once, so it will be, if it's continue moving hands, it will pay again and again HST forever and ever?
Okay, you go and buy a car. You go down and see my son Jeremiah over at Direct Nissan, and you buy from Jeremiah an Armada, and you drive away with your $100,000 Armada, and you paid the HST. I come to you 6 months later. I like the Armada. Sell it to me, please. I need that Armada. I like the. Am I paying HST on it? Yeah. Right, and then 6 months later, I sell Jim that Armada. They're just collecting it over and over. This is the world of government. It's fantastic, right?
Is this regardless if it's individually deeded or not?
Like, the thing is, if it's not deeded, you can't even sell it. So when you have a parking spot locker, is it owned or exclusive use? One of the things with exclusive use means exclusive use tied to that property. You'd have to get the whole declaration changed to be able to shift that exclusive. It's not happening. So this is where for some people, they get a little iffy because they know if I'm living downtown Toronto and I have a parking spot worth $100,000, it's exclusive use, I can't actually sell the parking spot on its own. So yeah, it does have to be physically deeded. And when we start getting into condos, like not all deeds are created equally. So if I got a tandem parking spot, that might be on one deed. I have the parking spot with the locker right behind, that could be one deed. So we have to make sure of how they're set up because we can't always just break them away. And we got a whole bunch of clauses in here in the future, very similar from a condo point of view. If you ever work in a condo as far as status certificates, and conditions, etc. Things that you may want to consider to put in from a protection standpoint. And general conditions as well, we just included here for your reference. If you're ever counting these particular scenarios we have in the headings. As far as status certificates go, inspections, the one thing I'm going to say generally on conditions is please, rewinding back, read the conditions, read your agreement, okay? So, I've seen it too many times. You have a condition in for an inspection. And you didn't read the inspection condition and you thought that the buyer can just walk away from it. First of all, you can never ever just walk away from anything, no matter what pretty much the agreement says. If the agreement says there's a status certificate review, there's a financing condition, a home inspection, you actually have to have something wrong to say, I'm not going ahead with it, even though it says in the buyer's absolute discretion. If you come back on the status certificate and you know what, in my discretion, I don't like it, but the reserve fund is $15 million, the common expenses have not gone up at all in the last 2 years, the budget is fantastic, how are you gonna argue there was something wrong? So just always warn your clients, when we're going ahead, this is not a catch-all for you just to get out of the deal, okay? But from the, I'm just gonna mention about the inspection part, and then I've read conditions where it says, if there's an issue found with the property, then the seller is allowed to remedy it up to the value of $5,000, $10,000, whatever it is. So there's some inspection conditions which are in favor of the seller, some more in favor of the buyer. So be careful of what the wording actually says from a protection standpoint. Yes?
Yeah, I have a question. Let's say someone has like mortgage condition financing and they're not able to get approved in that time frame. Do they need to show like a decline letter in order to get out of the agreement then?
My argument is you do not have to show that letter. You don't have to show them anything. If I get my home inspection done, and I'm not happy with the inspection clause, the condition of it. So they'll say, send me your inspection, send me the binder. No, not going to do it. But if you're going to go to court, you're going to have to show the judge something, right? So just note, if you're not going to provide it, that's fine. But what I would suggest is then talk with the lawyer about it. Maybe what we're going to do is we're going to cut and paste some of the items that were found that are substantial enough to show. Because on those inspections, they have all the pictures and the thing looks like the worst thing in the world, right? Put enough to scare in this up. I would put something, but again, pick and choose. But you can't give your seller the ammunition. If there's nothing wrong and you gave them the whole inspection report and they went through it, I would say not great. I don't like sellers remedying anything ever, generally. If I'm the seller, of course I want it because guess what? The buyer's gonna have to close no matter what. So I'll say I remedied it and I didn't. Decide what's wrong with the property, put a dollar figure on it if you're the buyer, get a rebate, and just let the buyer go and fix it afterwards. Just note that if you're gonna get the seller to do the work, they're probably not gonna be very happy with it. Then we start getting into all these long clauses where it says that seller has to remedy the work, we have to do a holdback, buyer has to be satisfied. If buyer's not satisfied, then we have to pull the money out of the holdback. It gets very, very messy with these conditions. So try not to make it that the seller has to do work is my advice on that. Even if the clause is not there for inspection, reinspection, you get 3 visits, everything else, by law, the buyer can still come check the property right before closing. But I wouldn't leave it to insisting on, well, we have the right regardless. Just give yourself enough visits and save yourself 1 visit and try to get the property viewed the day before closing, the day of closing. If the last time you went to visit the property was a week ago, less likely then we're gonna have more ground to stand on. If we know that there's something wrong with the property, doesn't mean the seller's gonna fix it, doesn't mean that the buyer's gonna get out of the deal. What we're gonna be able to show is, seller, we visited the property the day before closing. These things are wrong, you need to fix it. And now we start the negotiation if there's going to be a holdback, anything like that. Otherwise, when we go to sue you in court after closing, we knew that this was wrong and we brought it to your attention before closing. They look more wrong that way. So this is where going to inspect the property ahead of time. If you already know that there's a bunch of stuff wrong with the property and you think there's going to be a holdback need, talk to the lawyer. Let's put the holdback in from day one when we're putting the agreement in. As soon as the deal went firm, contrary to what everybody believes, and you say, oh, let the lawyers fix it, they're going to go to the magical land of holdbacks. There's no guarantees of holdbacks in life, and nobody has to agree to it if it's not in the agreement. So whether it's a swimming pool, the defects, whatever's wrong that the seller has to fix, and you want to do a holdback, we need to do the clause immediately during the offer stage. Okay, and the idea of the lawyer's approval, like, it's kind of funny because I'm not the one approving it. I'm not telling the client, well, over my dead body, you're going to buy that property. You know, it's not my call to make. It's really my buyer's. But if you're going to have something that you're not certain about, whether you're the buyer or seller, it's not a bad idea to put a lawyer review clause in there, because guess what? Now you're pulling the liability off of you onto the lawyer, right? If you're saying, seller, you know what? We got this deal in, but this offer looks a little complicated. Let's put a lawyer review clause so you can go and confirm with your lawyer that you're comfortable with it. Because otherwise, if you don't put the lawyer review clause in there, they let them accept it, it's a complicated deal, and you prejudice your client will come back to you and say, hey, I didn't know I could go to the lawyer ahead of time. How'd you let me accept this deal? So on assignment deals, I always put lawyer review clause for both ends of it. Commercial transactions, always put a lawyer review clause on both ends of it. Protect yourself that way. Okay, financing we know all about. And again, if you're acting for a buyer that's going to be getting a mortgage, get them to work with the mortgage broker. Like, they should be all good with their mortgage broker before they even went to view the property with you. Don't take them to see 50 properties and fall in love with it and saying, oh, wow, this is beyond our means, but I'm sure we can do this. Because they're going to go speak with the mortgage broker, they're going to laugh at them, and then you wasted a whole bunch of time. This used to be very, very irrelevant. This is now coming up more and more and more. Why? Because in this market right now, properties are sitting for a little while. Buyers come and say, hey, guess what? I'm in the driver's seat, so guess what? I want to buy your property, and I need to sell my property, so I need to make this conditional on me selling my property. We all know this is a lot of headaches. Buyers not selling their property, the sellers coming and saying, oh, you didn't market it properly, I didn't see it on the MLS for weeks, whatever the thing is. Bottom line is, normally it says in the offer that the seller can continue to market the property, and if they get another offer in, then the buyer has to firm up. But this gets very messy. If you are selling the property, of course, you would try not to have that, but sometimes you don't have a choice with it, so just watch from the timelines and everything else. Okay, and there was the escape clause, we talked about that. Okay, this one is rare. I've never ever seen this one where the deal is conditional on seller finding accommodation. So seller saying, hey, I have nowhere else to live, so I'm gonna sell you the property, but I gotta find somewhere else to live. You know what, if that's the case, where at all possible, I don't love the idea of saying, seller, you know what, we're good people, we're gonna buy the property from you, we'll let you live in there, and then you just leave a month or two later. Because if that seller doesn't want to leave, you can't just call the police and boot them out. Now, are they a tenant? Are they not a tenant? I like to keep extending closing until the seller is out, and I'm not inheriting the seller as living in my property. It gets kind of messy that way. Okay. The ability to sign the agreement. So this doesn't come up that often, but sometimes people flip deals like they do in new construction. You actually need a clause for that. If you're buying the property, but you're thinking, I may want to put it on a family member's name, I may want to put it in my corporation, whatever it is, you need clauses for that. Otherwise, you can't just direct title typically. Why? Because the bank won't accept that. The bank will say, I want the names on the agreement to match the names on title to match the mortgage. So it's in your name and you want to close under corporation. I want you to amend the deal to put the new name as the company, and I want the seller to sign off on that. Without a clause in there, the seller's not signing anything generally. But if I'm the buyer, I want to put in the clause saying, I can assign this deal at any point to an existing new company, whoever, and as soon as I assign it, I'm off the hook. I'm no longer a named buyer. If I'm the seller, I just got an email on this 2 days ago, actually, and they're saying for the mortgage purposes, somebody has to be removed off the title or else we can't get the mortgage. That's fine. We'll remove them off the agreement, but they still have to be liable as a named buyer. So if I'm the seller, I want everybody to stay on the hook right up until closing. If I'm going to buy Jim's property and I form a new corporation and then I don't close and I'm off the hook, what does Jim have left to do? Sue against a brand new company. Jim's not going to like that. So this is where be careful when you get those amendments in, and agents try to pull a fast one. Oh, we just need to add somebody on title. We need to just remove somebody. Talk to the lawyer first. Don't just sign assignments and amendments blindly. Chattels, equipment, fixture, we could talk about this until the cows come home. So one thing I will mention on there, still comes up time and time again with issues. If you're acting for the seller, ask them what rental contracts they have. Get in writing from them, send them an email. I had a great appointment with you. We're going to list your property. Please send me a list of all your rental contracts. If they don't tell you of a rental contract and you don't list the hot water heater, for example, and then it's time for closing, the buyer's not going to assume the contract on the rental. They're going to demand your seller to buy it out time and time again. Chattels and fixtures in good working order, normal working order, whatever it is. Watch this kind of verbiage on it. If it's being sold as an estate sale, elderly couple, you may just sell it as is, where is. You may say, look, this property's 50 years old. I don't know if these things are working or not. If you have this scenario as a seller and you can sell things as is, sell them as is. And also not all as is clauses are created equally. So like you have a case where like the property is very decrepit and people don't know what's wrong with the property. Like we can have a very expansive as is clause so that the buyer can't come back on anything literally. So this is where you have to take that on a case-by-case basis. If you have a certain chattel fixture, you're not sure if it's being included or not, ask your client. If you are expecting the TV to be included, then put the TV in as a chattel. If you are the seller, put fixture excluded, TV, be as expensive as possible so there's no misconceptions. So that's how you draft an agreement purchase sale, issues to come up with. I know it's very, very expansive, but what I would tell you is you have this presentation as a PDF. When you encounter a certain item, go back to the presentation, go look at that item, and if you're not sure, contact me. Happy to help. So thank you everybody for coming today.